Civil Activity 1 of 2025, Material versus Material and others.
May please the court notes L.A. Malaki on behalf of the appellant.
May it please the court, my lords, Advocate K.W. Viduka for the first respondent.
For the first respondent.
That is so, my lord. Any appearance for the remainder of the respondent?
None, my lord.
We will await the outcome of the decision.
That is your lordship.
Yes, Mr. Lord.
My lord, I wish to start with the facts, which are very narrow in this case. The summary of the dispute is as follows. The late chief Lechesa Jonathan Mateadira had two sons. The firstborn son is the husband to the first respondent. The appellant is the younger brother of the first respondent's husband. The unfolding of life's situation.
No, sorry.
Yes,
Chief, the first chief is
Chief Lechesa Jonathan Mateadira.
Yes.
Yes,
So he had two sons.
two sons.
Yes.
The first son being the husband to the first respondent.
Yes.
And the appellant being
What was his name?
the first son,
Yes.
Sehlooho Lechesa Mateadira.
Okay.
Now, what happened, my lords, is that
And the second son?
the second son is the appellant, Joel Lechesa Mateadira.
Yes. And who is the first respondent?
First respondent,
No, sorry, the first appellant. I mean the appellant. Who is the appellant?
the appellant is the second-born son of the late chief
Okay.
Lechesa. No, my lord.
Nyeoe.
Nyeoe. That is so, my lord.
Okay.
He is the second-born.
Square.
That is so, my lord.
Okay.
Now, the first respondent is the wife of Ts'ehla, Lechesa Mateadira.
Yes.
And the common cause on record, she is widowed.
Yes.
The firstborn son passed on before his father. And then the father continued with his reign. Now, immediately when Chief Lechesa Jonathan Matiarira passed on, the wife of the firstborn son was then installed as the principal chief. Those are matters that are common cause. The narrow issue on appeal is the appellant's contention, the second-born son, that, oh no, the way chieftainship matters work in Lesotho, patriarchy is given recognition. In the absence of my brother, I am the one who ought to have been the principal chief. In the end, my lord, the real issue, simply put, is the chief has two sons. The firstborn son, who by law is the person who should in fact succeed to the office of chief, predecesses his father, who between the widow and the second-born male should be chief. My lords, that is how narrow our appeal is.
Didn't the first respondent have a male heir?
No, my lord. Even on the facts, the first respondent does not have a male heir. It is actually one of the issues on the basis of which the appellant is actually buttressing the point that, oh no, the fact of the matter is, customarily speaking, the spirit of the Chieftainship Act and the amendments, it gives the preferential right in chieftainship matters along male lines before women could be considered.
Yeah, because at typical Sehlooho law, we'd have argued that the heir of my heir is my heir, isn't it?
That is true.
So even if I were to predecease my father, if I had an heir at customary law, that heir of mine would be entitled to succeed my father.
That is true. And
but then legislation came in to say when the deceased passes on, leaving a wife behind, then the wife becomes a substantive holder of the office.
that is true, my lord.
So what is the quarrel?
The quarrel, my lord, is this. I just wish to go to the record so that I will put the issue more in context. If their lordships were...
As you address or tell us what the quarrel is, I just had a look at your grounds of appeal.
Yes, Lord.
You can see all of them. The initial ground of appeal, you're complaining about non-deliverable of judgment or something like that.
No, my lord. No, my lord. That one is not...
Just enlighten us on that. Which grounds are you pursuing?
That one, my lord, is no longer being pursued.
Which ones are you pursuing?
The issue was, in fact...
It was not the ground of appeal in the first place. Is it?
It is, my lord. We have got a lot of jurisprudence of this court to the proposition that if a decision is made that is not accompanied by reasons for judgment, it will be taken as arbitrary.
Well, that's a matter for another day.
Yes, thank you. Yeah. But for today, we are not pursuing that one.
Okay. Which one are you pursuing?
My lord, we filed an additional ground of appeal on the 8th of September. And I was made to understand when during the roll call that in fact everything was made to be in order as at the time when His Lordship, the President, was raising the issue that on this record there is but only one ground of appeal. It is but a 2-page document.
Entitled additional grounds of appeal.
That is so, my lord.
Which is that ground? You are saying you are said there is only one ground of appeal. Here you have 1 and 2.
Well,
The way you have itemized that is 1 and 2, which one are you pursuing?
my lord, I humbly submit that I am pursuing specifically number 2 for the simple reason that they are intertwined. The issue that relates to number 1 is something that is common cause effects in terms of the hierarchy of the sons of the late chief. In the end, my lord, the issue will be narrowed down to which of the 2 competing rights for the disputants who are before court should in fact be given recognition. And I wanted to proceed in that light.
I think I'm looking at how you have coined this ground that the court did not grant the judgment, as you only have found that the appellant's eldest brother predeceased their father, chief. I would have thought that that was common cause, isn't it?
It is, my lord.
What is the ground of appeal?
What is the ground of appeal?
What are you appealing on?
My lord,
Even with respect to the first one, that the appellant was the surviving and eldest son. I doubt if the eldest son is correct. Yes, he was the surviving son.
may I beg the pardon of their lordships? I just want to ensure that there is nothing omitted there as I address the court.
Because you cannot pursue a new ground of appeal, isn't it?
That is so, my lord.
I understand
Yes.
you to be arguing that
This is the issue, my lord. I can see what caused the confusion. Our issue, my lord, is this. Our ground of appeal, which is at the heart of this appeal, is whether or not the appellant's right to succeed to the office of principal chief is subservient to the right of the first respondent. That is the only issue, my lord, that we are before court with.
which ground is that?
The one that appears in the grounds of appeal, it reads, the appellant's elder brother predeceased their father, Chief Lechesa Jonathan Matiadira.
No, it starts here.
Yes, my
The
lord.
court below erred in not granting the judgment in favor of the appellant,
Yes.
as it ought to have found that
Then I go to number 2.
the appellant's elder brother predeceased their father. And then you say, and based on the above, the appellant's right to succeed to the office of chief was not subservient to that of the widow of the first respondent's late elder brother.
Yes.
Hey, we went to another one. What's it? So you are saying, and who is the first respondent? So you are saying the court below said, well, the appellant could only succeed if the first respondent could not succeed. Is that what you are saying?
Well, according to the court below, its interpretation is the widow of the firstborn son has, in terms of hierarchy, the first right to succeed to the office of chief before we can in fact go in descending order to the person who comes next, to the person who by statute ought to have been chief.
And you are saying the court was wrong.
We are saying the court was wrong.
Okay.
And that it is a matter of interpretation of the law as is on that issue. My lords, I have to put the issues for debate in an orderly fashion to say, Chieftainship Act 1968 was a subject of amendments. And those amendments being the Chieftainship Act Amendment of 1974. It is the one that introduces the position of widows in Section 2. It reads as follows. Section 10 of the principal law is amended by inserting the following subsection after subsection 3. And then the amended subsection 4 reads, I quote, the only surviving wife of a person or the surviving wife of a person who, but for his death or incapacity, would have succeeded to an office of chief, succeeds to that office when it is vacant, and she has no male issue. Now,
And that is a reference to the first respondent.
that is reference to the first respondent. Now, my lords, when we look at page 93 of the record, Her Ladyship has properly captured the sequence of the sections, in that she then incorporated this amendment into Section 10 in the original principle, in the original act, so that there is a coherent reading of Section 10. In the end, the argument which the appellant makes before their lordships.
Let me understand.
Yes,
There's what? Section?
Subsection 4. Yes, my lord.
Section 4.
Yes, my lord. Yes, my lord. The sequence has been put in the proper format. Now, my lords, I come to the reading of Section 10 as is, incorporating the amendment. Now, it postulates that if at all the holder of the office of chief passes on, the firstborn son should in fact succeed. And in the present case, the firstborn son, it is common cause that he is no more. Now, I wish to come to the next subsection, being subsection 2, which appears there in page 93 of the record. It reads as follows. When an office of chief becomes vacant, the firstborn or only son of the first or only marriage of the chief succeeds to that office, and so in descending order. That person succeeds to the office who is the firstborn or only son of the first or only marriage of a person who, but for his death or incapacity, would have succeeded to that office in accordance with the provisions of this section. Before I can dissect it, your lordships, with your permission, I wish to read subsection 3. If when an office of chief becomes vacant, there is no person who succeeds under the preceding section, the firstborn or only son of the marriage of the chief that took place next in order of time succeeds to that office, and so in descending order of seniority of marriages, according to the customary law, that person succeeds to the office who is the firstborn and only son of the senior marriage of the chief, or of a person who, but for his death or incapacity, would have succeeded to that office in accordance with the provisions of this section. Now, while at this point, my lord, I wish to paint the following scenario before I deal with subsection 4.
Before you paint the scenario,
Yes, ma'am.
in the quarter 4, on which profession did you rely? Because you have several subsections.
We were,
Looking at your following evidence.
Yes, my lord.
Once one better appreciation, on which profession did you get that thing?
our reliance, my lord, is based on both 2 and 3. Thank you, my lord. Our argument is, assuming the late chief, that is the father of the appellant and father-in-law of the first respondent, had several wives. We would need to exhaust first the right to inherit the seed from the first house, where the appellant is the second born in that house, before we can go anywhere. If the court is with us in this line of approach.
No.
Well, Your Lordship.
No, sorry. You are leaving me behind.
Yes, my Lord.
In this particular case, was there a second marriage?
No, my Lord. That is why I said.
So why do we speculate on the basis of something that doesn't exist?
I want to address, my Lord, the issue as to what subsection 3 was intended to serve and show its importance, and how I am trying to persuade their lordships to approach the matter as a result. His Lordship allowing me that small latitude. Yes, my Lord.
Enjoy it.
Our argument is this. Suppose there were many families in the yes, my Lord.
Marriages.
Many marriages. Thank you, my Lord. Before we can go to the second house, which is talked about in subsection 3, we would first have to say, are there no people who qualify to succeed in the first house? And the appellant is saying, I am here, I am alive, my brother is absent, I am the surviving male in this house of my father, and therefore I am the one who has to be given preference. Exhaust first the descending order that is inferred in subsection 2 before you go anywhere else. And that's my Lord.
Isn't it the case that subsection 2 is talking about marriages?
The one that talks about.
Just read it again.
Which one, my Lord?
Subsection 2.
Subsection 2 says, when an office of chief becomes vacant, the firstborn or only son of the first or only marriage of the chief succeeds to that office.
Yeah.
And so, in descending order, that person succeeds to the office who is the firstborn or only son or only marriage of a person who, but for his death or incapacity, would have succeeded to that office in accordance with the provisions of this section.
I'm interested in the use of the word marriage. Which marriage are we referring to in that section?
I submit, my Lord, that we are talking about the first marriage.
The first marriage.
The first marriage.
Wouldn't that be a second marriage? Or you are saying it still refers to the first marriage?
Yes, my Lord.
Where the first male-born child was born?
Yes, my Lord.
So you are saying if he has younger brothers, so the younger brothers would be entitled to succeed?
We are saying the younger brothers would be entitled to succeed if at all the marriages were made before we go to the second house or the third house. Because interpreted otherwise differently, it would mean if at all the preference has been given solely for the firstborns, the other interpretation would be where there are many marriages, we first have to exhaust the firstborns in all those marriages. When we are done and there is no firstborn in all those marriages, it is then that we will then come to the widows and then say, who is the first widow? In line of the hierarchy of the houses. Yes, my Lord. And then, my Lord, our narrow argument then is, before we come to widows, we first have to exhaust
the males.
The males. That is our interpretation. If the court is with us on this issue, we submit that the appeal should succeed. Similarly, if the court is not with us on this issue, the appeal should not succeed. My Lord, this submission having been made up to this far, we go to the decision which we have attached to our heads. We have attached the 1975 case of Sehlooho Malebanye versus Ts'ehla Goliath, reported in the Lesotho Law Reports, 1974 to 1975. And in relation to this case, we make the submissions which appear in our written heads of arguments, the relevant part being page 12, paragraph 29. That is where we start the argument in that regard. Now, my lord, I wish to refer their lordships to paragraph 31 to be specific, page 30. Now, if I were to just go over these heads from that paragraph, the summary of the facts of the judgment that we have attached are that Chief Goliath had many wives. First wife died without a male issue. Second wife had 2 sons. And being Lesupi and Muale, Lesupi passed on at an early age. Muale was to become chief, but died during the preparations for his installation as chief. Now,
that was unfortunate, wasn't
it was very unfortunate, my lord. Very, my lord. Now, the widow of Muale being Sibue, the appellant in the decision was left without children. Then Sibue was installed by Chief Goliath at the area that was intended for her late husband. Now, the third wife of Chief Goliath, being Machabasiwile, had her eldest son, Chabasiwile. Chabasiwile was also placed at another area under his father's area of chieftaincy. Upon the death of Chief Goliath, the dispute arose in relation to who should be the successor to the seat of the late Chief Goliath at his main area of Tsikoane. Sibuen then objected to Chabasiwile being made chief at Tsikoane. She based her argument on the section 10 subsection 4 per the amendment. The court then rejected her argument and dealt with the interpretation of that section in page 279 of the attached judgment. And then the court said, I wish to read it, the first part for emphasis. An act of parliament must be interpreted in accordance with well-known canons of construction. The court cannot attribute to it an intention which appears nowhere. The amendment does not confer upon the appellant the right she claims to succeed, and can succeed only when there is failure or extinction of sons from any house of the deceased chief. My lord, Judge Cotter, his lordship, when he dealt with this matter, gave due recognition to the fact that it is entrenched in the Basotho way of doing things that patriarchy takes place as a matter of preference. Exhaust the sons first before you go to the females. My lord, I am trotting on a thin ice in view of the fact that his lordship, the president, was appearing in the Masopa.
it? It's terrible. That
Yes,
is what is crossing my mind.
Masopa matter.
As you speak.
Yes, my lord.
Because I...
And his lordship, Justice Molete, said, well, we appreciate the fact that the way Basotho have organized their societal affairs appears somehow to be giving certain preferences more to men than women. Yes, it might not sound fair on the face of it, but unfortunately it is how we have organized our affairs by our social contract as Basotho. It is us. It is how we are doing things. It is the Africanness. It will in fact go alongside the quote, celebrated quote of Kwame Nkrumah when he says, look, I'm just not an African just because I've been born in this continent, but it is because the continent has been born in me. We are assault. And here we are saying, put the men first. And of course, if at all we are saying, we want to appreciate modernity and give due recognition to women, let's then maybe go for referendum as a country and then remove the exemption that we have to the Convention on the Rights of Women, obliterate Section 18 of the Constitution from our Constitution, and then stop coming to the issue where we have to say the issue of masculinity has to play a role in determining rights of people. Unfortunately, as we speak today, 9th of September 2025, the law remains as it is. Patriarchy is given due recognition, bad as it may sound, because it is not in all cases that it may appear to be justified that it be given due recognition. My lords, the nub of our argument in this appeal is it proper that in terms of how this section 10 has been drafted with its subsections, we in fact come to a position where the widow is given recognition before the sons in the descending order in the first house are exhausted. My lords, I submit that their lordships will have an in-depth look into this matter, even following our submissions with my learned colleague. In the end, the reality of this case is immediately following their lordship's decision, there's going to be a lot of shaking and movement within the country because people are going to say, we want to align ourselves with what the Court of Appeal has endorsed as the proper way of dealing with these chieftainship matters under the scenario at hand. I submit, my lords, lastly, that whichever way the appeal falls, it is one of those cases that we cannot attribute any form of malice or frivolity to either of the parties to have been before this court on this contentious issue, such that whichever way the appeal falls, I submit their lordships should not make an order as to costs. My lords, these are our arguments in this matter.
We appreciate Mr. Momat. At what stage does subsection 4 kick in your argument?
I submit, my lord, subsection 4 will kick in only when we have said first, in the house of the chief, there are no other male people in the house of the first house. But since here there was only a single house, if there are no male people present, then section 4 should kick in. That is our submission.
Also, you appear that continuously reference is made to the firstborn or only son.
Yes.
Firstborn or only son of the first.
Yes.
Where does the second-born feature?
My lord, I submit that the second-born will feature for the fact that there is reference to this element called descending order. Remember, my lord, that when you go downwards on the section, you will even come to the point where it is said, the more you exhaust the people with the preferential right, you will even have to come to even to a position where you say, within the chief's family, there are no people who qualify. Now let's go back to the late chief's brothers and see who was the brother who came next after him, who would then succeed. It is in the end, my lords, the issue of the hierarchy. Who between these co-disputing litigants comes first in the hierarchy of those entitled to succeed? It is the issue that their lordships are going to determine.
Just remind me, Mr. Mugadi, it seems like there is, don't we have an amendment in 1985 that regulates a situation where widows are left after the passing of their husbands?
It is the one, my lord, I've
1985. I can see you are arguing 1974. But 1985, can we have anything there?
Well, as we were traversing this matter, my lord, we dealt with 1974 and we also dealt with 1984. I do not recall that we dealt with 1985. It is because, my lord, the one that specifically talks about the widows is the 1974 one that introduces that subsection 4.
And then it is the section that says when a husband passes on and there is no male child, then the widow can come in.
That is so, my lord.
And you are saying that should be interpreted to mean we have to exhaust the list of the brothers, junior brothers, to the deceased before we come to the widows.
That is our argument, my lord, and which we say, if their lordships are with us, we carry the day. But if their lordships are not with us, then we don't carry the day. Thank you.
Okay. I think I hear you.
Those are our submissions, my lord.
Thank you.
Thank you, my lords. I want to first start by.
I don't like this your case, Jan.
My lord,
This thing, I have a daughter. I have a daughter. I don't like the case.
oh, I get the point now. I was lost. Yes, my lord. My lords,
And I also have a wife. So if you want to argue this like this, you're spoiling my mood.
No, my lord. Yes,
Yes.
my lord. Yes, I want to first want to clarify that the situation in the case of Malabanye versus Goliath, which my colleague referred to, doesn't neatly fit into the effect of this case. In fact, the principle which we are pursuing, which was pursued when the first respondent was installed, was in fact pursued in that matter. Because Sibue, who is referred to in that case, was actually installed in an area to which her husband was supposed to be installed at. And here is our case. Section 10, my lords, subsection 2, and the other following subsections, they are very clear that this is the line that is going to be followed when answering the question as to who should succeed to a vacant office of a chief. And in this matter, the issue boils down to the interpretation of the words that are used in subsection 2. I actually thought my colleague would explain to the court why the legislature will be referring to a firstborn son or only son. Why use those words? If then we're going to interpret subsection 10, subsection 2 to mean that it also refers to second-borns, third-borns, and so on.
100 years.
Yes, ma'am. I submit that reference to the firstborn or only son was just an emphasis that the person who would succeed under that subsection is the son that was born first in that marriage. Otherwise, there is no reason why the legislature elected to use the word firstborn son. And as we go down the section, at subsection, what is now subsection 5, the court will realize that at section 10, subsection 5, the language changes. If nobody has succeeded under subsection 2, 3, and 4, and all the wives of the chief are deceased, it then says the legitimate surviving brother of the chief.
Only time it accommodates the legitimate surviving brother.
Yes, ma'am.
Not when the wife is dead.
Not when the firstborn is, yes, ma'am. So I'm saying the way in which the legislature has used the words in this section is very important and key in interpreting the meaning of this subsection. We also have to ask ourselves one very important question. We already had section 10.4 before the amendment, which talks about the surviving brothers. Why would the legislature then specifically insert this provision that talks about the widows immediately after subsection 3? And our submission is that the reason was that if none of the firstborns have succeeded, then the door was open for the widow of that firstborn son who did not succeed because of death. Otherwise, then we would have had subsection, the amendment, that insertion I submit would have been under section 10, subsection 4. And it is very important to refer to, or before I do that note, I submit that reference to descending order in section 10.2, we are talking about the marriages, not the sons. Because the sons we are already told in that subsection that we are talking about the firstborns or only sons. Only sons would apply where the chief has only one son in that marriage. And firstborn son would apply where there is more than one son, which is the case in this situation. Chief Material had 2 sons. The first one passed away. The second born son can never be referred to as the only son of Chief Material, which is the case that is being advanced by the appellant.
No, he's saying descending order.
Yes, my lord.
For him, descending order means it also applies to the sons. I mean, the marriages and the sons. We say, okay, marriages, we understand we don't have many marriages in the case before us. But we have more than one son. But this more than one son has a wife. And the wife is a widow. Now the question is, are we saying where a widow is left, is still alive, we can go to the second son to the exclusion of the widow simply because she's a woman? Is that what we are saying? In fact,
Well,
then it says no, exhaust the list. And when you are done, go for the women.
No, that is not the correct way in which we exhaust the list in terms of that subsection.
Yeah, let's address this descending.
Descending. May I read those 3 lines first? Then I'll make a submission so that my lords can follow what I'm saying.
Yes.
Section 10.2 reads as follows. When an office of chief becomes vacant, the firstborn or only son of the first or only marriage of the chief succeeds to that office.
And that is a reference to the husband of the
First respondent.
Of the first respondent.
Yes.
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 Second.
And maybe I should address this while I'm there. And I am saying that cannot be the only son that is referred to in that subsection. Because we are clear that the first son is deceased.
Yeah.
Only son can never be the second son.
And the second son can never be the first son.
Yes, no. So I'm saying what is being referred to there is the firstborns. And the reason why the subsection says, or only, it uses the words, only son of the first or only marriage. The reason why we have first is because it's possible that there could be 3, 4, 5 marriages. But our concern is that firstborn son of the first marriage, or only marriage if it is only one marriage. And now it goes on to say the descending order. And so in descending order, that person succeeds to that office who is the first born or only son of the first or only marriage of a person who, but for his death or incapacity, would have succeeded to that office in accordance with the provisions of this subsection. So under subsection 10.2, actually we have two classes of people who can succeed. It is the firstborn son or only son of the chief who was holding the office, or the firstborn son or only son of that person who, but for his death, could have held that office. So the second part refers to the son of Chief Ts'ehla, not the father Matadira.
I see.
Yes. So here's my submission that we cannot take that word used descending order to mean that when we move from, we have to move from the firstborn son to the second-born son, who is the appellant. And I'm saying then the legislature would not have bothered to use the words firstborn son or only son in that marriage. That distinction is being drawn because the legislature was saying the second-borns and third-borns, the door is closed. The only time that you succeed as the second-born son or third-born son is where a scenario under section 10.5 has arisen. And that is the nerve of our submission, that the proper interpretation of that subsection 2 cannot be that we now have to move on to the second bonds. Then the legislature would have clearly stated that, the sons, why not use just the words sons of the chief? Firstborn son or only son. So those are our submissions on this point, my lords. And I wanted to refer to the Senate Masopa decision just on the law, not necessarily what was the bone of contention in that matter or what was decided, because it decided in my head, my lord. It's reported in the 2013 to 2014 Lesotho appeal cases, and it appears at page 211, where it explains this phenomenon of why the women have to be considered in this line, because we know in terms of customary law, as it was before the statute, when it comes to succession to the office of a chief, we only talked about males, and of course the wives of the chief who was holding the office. Now at paragraph 11, this is what this court stated in laying down or in explaining how these two have been mixed. It is nevertheless apparent that the High Court's judgment, Court's 1943 judgment in the Griffith and Manshewa Sage of Griffith, 1926 to 1957 HCLR page 50, that women could then at customary law succeed to the chieftainship in their own right. However, the judgment is not authority for the proposition that the rule of male, this word I always struggle to call it, promotion, yes, was no longer universal. Indeed, no argument to that effect was advanced in support of the appeal. It must therefore be concluded that what was meant in the judgment was that the women could become chiefs in their own right, but not in conflict with the pro-mignature rule. The appellant seems to be taking that, my client cannot have been succeeded to this office because of this rule. But it was stated even in this judgment that no, the legislature has made a decision that, this is the line that we are going to follow when it comes to succession in chieftainship. And women are put amongst those who have to succeed, as we have it under the amendment in 1974. So whatever interpretation the court ascribes to section 10.2, it does not necessarily have to be having in mind strictly that all the rule as it is. But it has to consider that there must have been a reason why the legislature decided to to
Amen.
amend it, my lords. So I submit subsection 10.2 can never be interpreted to include second bonds. And the court will even realize that even under section 10.5, the only time that the second bonds or the surviving brothers of the chief who was in office, it refers to those who the angles, because it will be saying if we had a situation where my client did not exist at all, then we are going to have a situation where section 10.5 would be applied, because we'll then have to ask who are the surviving brothers of Chief Matadira. Even before we come to Chief Matadira's second son or third son, and the court will realize there that now we are no longer moving in a descending order. The subsection states clearly that we are now ascending. So he can't come before the angles if we interpret those provisions to make sense, my lords. Those are my submissions, unless the court has questions now.
You guys. So your case simply is let the wife, the widow succeed.
Yes,
That's your
ma'am.
case.
Yes, ma'am.
And this case is let the appellant succeed.
Yes, ma'am. And for him to, he say, let the second son, let me just call it that. When we say appellant, it doesn't appear clearly that it conflicts subsection 10.
We are thinking about the second son.
Yes, let the second
It's
son
not contemplated by
succeed. What is going to happen when the second son succeeds and then later on he passes on? Clearly, we are now going to move into his own children.
But you have heard that Advocate Molati's argument is essentially that, you see, those words in descending order have to be interpreted to include his line.
Yes, my I would understand why he wants to push in that area. But I'm saying we should also consider, my lord, let's just imagine, let's assume the second son succeeds. Then he passes on. When will we have a situation where section 10.3 will apply? Because those sections are written in very clear terms, subsections are written in very clear terms.
And they are written in descending order.
Yes, my lord. So it means
Right
after the appellant, we are now going to move to his son or his wife and so on. My client will never appear anywhere, despite the fact that the legislature has said she should be in that line. Those are my submissions.
My lords, briefly,
Why do you want to jump ship and then bring in your client? When Mr. Bittier says, no, all of them are here, why does he want to come in? That's his argument, actually.
well, my lord, the fact of the matter is, as I had earlier, my lord made the submission that the trouble with this case is, following their lordship's conclusion of the matter, it is actually going to possibly cause another...
Change the whole country.
That is so, my lord. Because in the end...
No, the legislature will take care of it. For us, it's simply to interpret it.
That is so, my lord.
And we look away.
Their
As
lordships,
to what happens thereafter is their own interest.
their lordships will also recall that, and of course this issue has been pleaded, that another challenge that we are having in the present case is this. First respondent also does not have male issue, and it is accepted. And we are having a situation where, in line with the spirit of this act that talks to succession, one after the other, who is actually going to succeed her now that she does not have a male issue?
If she
That
goes,
is the consideration.
yeah, if she goes, then we shall see who comes in.
You see, my lord,
But before we cross that bridge, she's still there.
then it is that issue of saying, well, we are seeing that we are going to have this problem in 2070. Well,
We shall cross the bridge when it comes.
it will be seen by those who will arrive there.
It's
But,
another-
yes, my lord. But then it was inferred in the law that had the situation been such that she had a male issue who, upon attainment of the age of 21, would have to assume the role of chief, she would in fact be in that position properly. But the way the legislation has been crafted, she would not actually be there because she is substantive, but she would be there on some suspensive condition of some sort. In future, when the rightful holder of the office reaches 21, you vacate and the holder carries on. Hence, the great emphasis in the Section 3 of the 1974 Amendment Act, which specifically talks about the issue of exhausted brothers. My lords, other than how we have traversed the issues with my learned friend, I do not wish to carry the issues anymore.
I like the way you put it. Exhaust the line relating to the brothers.
As the court please.
First,
As the court
before you go for the women.
As the court please.
And then he says, no, my woman is here. When I go, she must pay if I have no heir.
That is my learned friend.
That's the case.
That is the case. Diametrically opposing interpretations.
Thank you very much, Advocate.
As the court please.
And thank you very much, gentlemen. We must appreciate your rather technical way of arguing. One did not have to be scribbling things. We had to concentrate. And we should be able to come back to you on the 7th of November with our answers to the questions you have posed.
As the court
And
please.
hopefully on that day in the evening, either the one or the other or both of you will be ululated. We thank you very much and you are released. That- Oh, no. The team shall be out.